Hi, I'm attorney Julie Hauf, and I want to stick to our recent theme of fee hearings just because there's a lot of attention on that topic lately, particularly with the Florida legislature considering some changes on the property insurance side that might help with some of what we're seeing lately in fee awards and fee claims by plaintiffs' attorneys. So I want to talk about the limited success doctrine. I've addressed it briefly before, but wanted to spend one video just talking exclusively about this, what the case law talks about with it, what you need to talk about with your expert, and what you need to ask the other side in a fee hearing. So limited success, I want to first go back to the basics, and we all know that what gets awarded here is the lodestar figure, which is the reasonable number of hours expended in the litigation multiplied by a reasonable hourly rate. The case law all says that once the court arrives at that lodestar figure, it can subtract from the fee based upon the results obtained. So it's that results obtained question that brings us into the limited success doctrine. The results obtained can provide an independent basis for reducing the fee when a party prevails on a claim or the claims for relief, but they're unsuccessful on other unrelated claims. So when they prevail on only a portion of the claims that they've made in the litigation, the judge is required to evaluate the relationship between the successful and unsuccessful claims and then determine whether the investigation and prosecution of the successful claims can be separated from the unsuccessful claims. So what's an example of this? Well, for example, let's say that you have a PIP case and there were a couple of different issues that were looked at. The plaintiff had filed a summary judgment and challenged whether the carrier could pay at the fee schedule amount. The carrier won that, meaning the plaintiff did not succeed on that portion of the claim. They might have made another challenge on a denied code, billed amount issue, 2% issue. Perhaps they succeeded on that part of the claim, so they're not getting everything that they asked for. So anything that was paid in the fee schedule was upheld. The carrier is not responsible for any more payment. But if there's some other issue in the case that does say, oh, they do get more money because of this, and that ruling's made, the plaintiff is then going to be entitled to attorney's fees. But are they going to be entitled for all of the time they put in the case, even the issue of that fee schedule that they didn't win on? This is why you need to know these cases, because the answer is going to be no. The court is to look at and indicate whether it is considered in its order the relationship between the amount of the fee awarded and the extent of the success. So similar to that third DCA case that just came out recently that I talked about in another video that says the order has to address, the plaintiff's expert has to address certain areas, this is another one of those things. The court needs to say in their order whether or not they considered the limited success doctrine. If they don't say that, that order can definitely be appealable. So let's talk about what the court is going to look at. You want to look at that order, first of all. Like we said, the order has to indicate whether the court considered the relationship between the successful and the unsuccessful claim. How do you do that? Well, the plaintiff's timesheet should have enough specificity there to tell you that this motion was on this topic, that motion was on that topic, and to cross that out. Now, as an expert, if you want to take those items out if you think that that's a limited success, and that's one of the things that I do when I try to prepare my reports. You also want to say it's not just that these amounts come out and they're zeroed out, because if the court decides the plaintiff can prevail on those amounts, you also want to give a reduction. So that if you have this issue coming up, you might want to consider that there's actually two different amounts that you say is reasonable. One is if that issue is taken out of the suit entirely because of the limited success doctrine, or if the court decides to allow it, you still want your expert to go back and look and see if the court awards fees for this topic, what would that reasonable time be? You want your expert to still be able to offer evidence on the fact of, well, if this is awarded, here's what that fee should have been if it's awarded at all. The courts, there's a second DCA case that talks about this as a Board of Regents case from 2005. Peterson versus Headquartered Consulting Corp. That's out of the fourth DCA from 2017. And again, it goes into that the plaintiff's expert needs to talk about this, as well as the defense expert. Some of these cases, when they get decided and remanded, and the higher court, the appellate court, says that yes, some of these services do need to be taken out because of the limited success doctrine. If the plaintiff's expert did not put any evidence on about this, and this is just like we saw in that recent third DCA case, and the only evidence that the court has to rely upon is the defense expert's testimony on that, that's going to be what's entered, because that's the only competent substantial evidence that the court has to rely on for that. So going through limited success, make sure that if this is an issue in your file, that you're asking questions about this, you're telling the court that it's their job to separate out that time and not award for everything. If they do think that that time should get awarded, make sure that your expert is also going to talk about what reductions might be appropriate for that time. Rather than just Xing everything out, make sure that if there are reductions to be put on for that, that's in evidence. Even if it doesn't come up at the hearing, it's on the expert's report. Make that catch-all statement at the end of the presentation of the evidence to say that while we strongly feel that this shouldn't be compensable at all because of the limited success doctrine, if Your Honor is going to consider awarding that time, please look at this report that's been put into evidence of the reductions for that. Just so it's not an all or nothing, you want to try to catch it if the court is going to award it, to make sure that there is some limitation and the reductions that are appropriate on that time as well if it does get awarded. So again, make sure that you are looking at this issue, that your expert is aware of this issue, that you're asking the plaintiff questions about this issue, you're asking the plaintiff expert questions about this issue, and that you get all the evidence in that you need to allow the court to be able to make a decision. If plaintiff's counsel is submitting a blank order to you prior to the judge ruling on the spot at your hearing, and they submit a blank order with lines that can be filled in for the hours to be awarded, the hourly rate to be awarded, consider and make sure whether you want some additional language in there or your own proposed order that the court did or did not consider the limited success doctrine or anything else that they might use to reduce the time that would otherwise be appropriate from the lodestar amount. Any questions, you always know where to find us. Thanks so much. Stay safe.